a lecture on the development of international human rights and humanitarian law. And I'm also very proud to introduce you to our illustrious lecturer, Mme. Claire L'Heureux-Dubé. Before I introduce you to Claire, I'd just like to say a few words of thanks to the people that have made this lecture series possible. The goal of this lecture series is generally to raise public understanding of legal issues essential to human well-being and to improve skills to engage in public debate and advocate for better implementation and enforcement of human rights and humanitarian law both in Canada and globally. Lawyers' Rights Watch Canada and our partner UBC Continuing Studies are offering these lectures free so that the information will be available to everyone. For those that can afford to do so, we hope that you'll make a donation when you leave so that the lectures can continue in the future. I would like to acknowledge and thank the people who've contributed to this first series. First, thank you to the funders for your unquestioning support. All of the groups and individuals that provided funds didn't ask for a proposal. They just spoke to me and said, "That's fine, we'll give you money." And they're listed here on the backdrop. The Social Justice Fund of Tides Canada Foundation, Dr. Arthur Clark of the University of Calgary, Ed and Julia Levy of the Elahi Foundation, Michael Goodman, Diana Davidson, and Mark Battersby. I'd like to also say thank you to UBC President Dr. Stephen Toop and other supporters at UBC, Claire Young from the Faculty of Law at UBC, and Stephen Owen, one of the Vice Presidents of UBC. A special thanks to our organizing partner, UBC Continuing Studies, and in particular Don Black, who's been absolutely wonderful to work with. Thank you to BC Campus, who's organized distance participation in this lecture series, and to Sandy Hertz, who's here tonight and who's making it all happen. As a result of BC Campus and Sandy's work, we apparently have 100 people online from places set tonight come to participate in Claire's lecture from Holland, Ontario, Alberta, California, and British Columbia. Sandy can correct me later if I'm wrong about each of those places. The lecture tonight is about human rights, the development of human rights and humanitarian law, the laws that developed after World War II, the conditions that made those reforms necessary, and the ideals and individuals that shaped the law. And now I'd like to introduce our lecturer. Claire L'Heureux-Dubé, formerly a justice on the Supreme Court of Canada, is an extraordinary Canadian woman, lawyer, judge, and human rights advocate. In Claire's career, there have been many contributions, accomplishments, and firsts. For example, when she was first appointed to the Quebec Court of Appeal in 1979, she was the first woman in Canada to ever be appointed to a Court of Appeal in any province. She has received many accolades and many awards, both for her performance as a lawyer, as a judge, and as a human rights advocate. Since 2002, when Claire retired from being a judge on the Supreme Court of Canada, she's continued her advocacy, but she's expanded her territory. She now works full-time, always on a volunteer basis, doing human rights advocacy and education around the world. The number of organizations that she's either helped start, sits on the board of, or works with are numerous and are based in many countries. Lawyers' Rights Watch is very fortunate to be just one of those organizations. In 2002, when Claire was still a Supreme Court judge and Lawyers' Rights Watch was little more than an idea in the heads and minds of a handful of local lawyers, Claire somehow or other got word of Lawyers' Rights Watch and took the time to write an enthusiastic letter of encouragement, and which was very encouraging, actually, because it was on the letterhead of the Supreme Court of Canada. So at the time, there were some people that thought it was a bit of a flaky idea to start an organization whose sole purpose was to protect human rights by protecting people that defend human rights around the world and who are in danger and difficulty because of their human rights advocacy. It's become much more clear that that's a necessary thing to do, but when people doubted whether it was a good idea or not in 2000, I could show them the nice embossed letter from Claire and show her endorsement. After Claire retired from the Supreme Court of Canada, she became a director of Lawyers' Rights Watch Canada. As a director and member, she has been a source of ideas, encouragement, good advice, and hard work. She has shared her time, experience, and knowledge with a singular generosity. Tonight, she is now going to share some of that knowledge with you. So could you please welcome Claire?
Thank you very much. So, the guy who works for this, please. This works, does it? Yeah. But I'm supposed to work with this. Are you awake there? Okay, thank you. Thank you. I don't like those microphones. So, thank you, Gail. She's a generous and a great friend. Has become a great friend. So they tend to exaggerate our qualities when they are friends. So and generous apart from that. So thanks for being so kind. It is a pleasure, really, to be here among an audience mixed, but I can see a number of students, and I'm a judge in residence at Laval University myself. I give lectures to the students, and it's my real pleasure in my old age to be able to communicate with the young people, our future, and hopefully tonight I'll be able to tell you a few things about human rights, which to me are very important and should be for you and everybody. So I really feel privileged to have been asked to give the first of a series of lectures on human rights and humanitarian law. This is, as you know, an initiative of Lawyers' Rights Watch, and it's more than wonderful director, Gail Davidson, who works tremendously for propagating the human rights, helping people who have, whose rights have been trampled all around the world. So I think Lawyers' Rights Watch owes a great thanks for all she's doing. But these series of lectures are to be saluted for many reasons, for principally three reasons. The first, we hope that eventually it will lead to the creation of a Human Rights Institute at UBC here. And a Human Rights Institute with research facilities in which, in order to understand and advance and further the implementation of human rights and humanitarian law nationally and internationally. Second, there is a need for the population to understand human rights in all its dimensions in order to further its purpose. And thirdly, students of all disciplines, not only law students, would greatly benefit from an exposure to human rights goals and realizations so that a real culture of human rights can be created at all levels of society in this country, hopefully this century. We don't have really a culture. We know about human rights, but I don't think that we have a culture of human rights yet. Interestingly enough, professionally and because of my volunteer work all over the world, I was in Pakistan at one point, and Pakistan, of all places, has had a project to build up a language of human rights for preschool children and all the years. So they build up a vocabulary of tolerance, of respect, of dignity, rather than these bullying that goes all in schools. We would, in Pakistan, have developed these vocabulary, if you want, up to the 10th grade. So this is one way of starting to understand and have a culture of human rights. And we haven't done it yet, but I think it would be a good suggestion that we start taking stock of the way we educate children in terms of language, of tolerance, and rather than other types of conversations that the youngsters may have. For example, how to treat handicapped children is important, how to treat people who are different color, race, and everything. So I think I just mentioned that because I was very impressed by that. So an Institute of Human Rights could look and research into those ideas and create a similar project and others for really people thinking and talking and in terms of human rights. So that being said, I would just like to give you a background and an overview of how this body of law we call international law has developed through the decennies and hundreds of years. Since the world is world, the desire for peace and justice has inhabited the hearts of all human beings and has been the goal of most, if not all, nations. The means to achieve it is what human rights is all about. Different civilizations and countries have at different times tried diverse ways to achieve this goal. They look at the best means to settle their differences. This is the case, for example, of equality, which meant different things to different civilizations in different periods, but was and still regarded as an essential condition to achieve peace and justice. The French Revolution is an example of inequalities which brought about the revolution of the masses in search of justice. I'll talk about equality later, but just as an example, how important the notion of equality is. And inequalities bring wars, they bring revolutions, we know that. So that's one way of achieving peace. In order for countries to achieve peace through mostly commercial ends at earlier times, treaties were concluded, and the notion of a law which would apply between all nations in case of conflicts emerged with rules which eventually formed a body of laws which became known as the law of nations, jus gentium, we used to say, and is now what we call international public law. This is different from international private law, which deals with conflicts of, mainly conflicts of laws between different jurisdictions. But the international body of law was built up with the treaties and from time immemorial. So international law regulates relations between nations and has its own tribunal, the International Court of Justice, to which nations which accept its jurisdiction do litigate their conflicts. The law of the sea is a very good example where a number of conflicts, some involving Canada, were brought before the International Court of Justice. There has to be some arbitration or arbitrate people who are able to solve problems with nations at the international level. Those of you who study at UBC probably know the Jessup competition, which is a way to interest students to international law and how to settle conflicts between nations. The advent of the League of Nations and its successor, the United Nations, the signature by all nations, or almost, of the Universal Declaration of the Rights of Man, as well as the recent creation of the United Nations of by the United Nations of International Criminal Courts for War Crimes and Crimes Against Humanity, all originate from a similar desire of nations to achieve peace and justice at the international level. At the national level, new constitutions were inspired by the Universal Declaration. It's the case of South Africa. There, it's a 10-year-old or 12-year-old constitution. India, 60-year-old constitution, and of course Canada, for that matter, were modeled with various differences, perhaps, on the Universal Declaration. In our charter, we find word for word some of the articles of the Universal Declaration. So the influence of the Universal Declaration is incredible and immense, and all for the purpose, I repeat again, to bring justice and peace through the respect of human dignity of people. Rather, they translate it in songs or whatever, love rather than guns. Well, that's the idea, basically. The notion of human rights and humanitarian laws as we know them today, whose aims are still to achieve peace through justice, is not really a novel one. It has diverse sources. It seems to have evolved from natural law, writings of eminent jurists and humanists, to eventually gain mention in some treaties, which would guarantee, among others, the right to freedom of religion. That's in 1713. That's the Treaty of Utrecht. The Treaty of Paris in 1763 abolished slavery. The Treaty of 1842 between England and US, and the Labor Rights 1906, to mention only a few, as well as the Hague Convention in 1899 and 1907, and the following convention for the protection of war prisoners and some civilians in armed conflicts, which are now known as humanitarian laws. So, however, in this is a long story of treaties, and the treaties were to end wars, but they also, at times, included protection for human rights, protection for prisoners, for humanity, and so established this body of law. However, in this part of the world, there is no doubt that the Magna Carta of 1215, the Petition of Rights of 1627, the Bill of Rights of 1689 gave citizens of the United Kingdom more protection than any country had at the time, and it is said to have inspired the American Bill of Rights in 1776, which in turn was instrumental in the French Constitution, La Déclaration des droits des citoyens, liberty, equality, fraternity, which of course terminated the French Revolution in 1789. So this is the general background, how we came to what we have today from what developed in the decades and siècles before. But both the First and the Second World War, with their genocide, atrocity, misery, and I could go on, were great incentives for the incorporation of human rights protections into international treaties and conventions. The Treaty of Versailles, for example, in 1919, which terminated the First World War, incorporated the Covenant of the League of Nations, which guaranteed freedom of conscience and religion to subscribing nations, as well as, and I quote, fair and human labor conditions. That was in the Treaty of Versailles. 1919. Other treaties with Eastern Europe, nations in particular, signed at the same time or later, went even further in guaranteeing the right to life, freedom of religion, equality before the law, and against anti-Semitism. It is, however, the horrors of the Second World War which were the prime motivation for the adoption of more specific guarantees of human rights in treaties. The Atlantic Charter, signed by the US and the UK in 1942, was to be, at the time when the US started to take part on the Second World War, was to be the prelude to the creation of the United Nations Charter in 1945, and the Universal Declaration of the Rights of Man in 1948. When I say the rights of man, of course, it's the right of men and women and persons. So there was finally political will to establish a system of international relations based on the respect of human rights. Both President Franklin D. Roosevelt and Winston Churchill, of course, and even Eleanor Roosevelt, who chaired the commission charged with the drafting of the Universal Declaration, which was called La Commission Consultative des Droits de l'Homme, I prefer to keep it in French, because that's my main language, have this political will to establish a system of international relations based on the respect of the rights of, or the respect for people, in fact, had achieved what was to become the heart of the human rights laws as we know them today. John P. Humphreys, a professor and dean of the law faculty of McGill, who was then the Secretary General of the newly formed United Nations, was very instrumental in the first draft of the declaration, as was René Cassin, an eminent French jurist, who incidentally was also involved in the drafting of the French Constitution as it exists today. One thing I would like to mention here, who were the prime motivation? It's wars, right. It's the misery, it's the horrors of the wars that were really moved people to go further and try to stop wars, to never to have wars again. It's not what is happening, but it's the ideal that was looked at. And institutions like the League of Nations, which didn't last that much, and I'll talk about it later, but United Nations, that's fine. Institutions are wonderful, but people are better. And in this movement towards respect for people and human rights, it's people like Woodrow Wilson, who was president of the United States at the time of the First World War. It was Roosevelt and Churchill at the time of the Second World War. It was Eleanor Roosevelt. It was people who made it happen. And I say that particularly because it's not, people with power, of course, have a chance to accomplish better, but everyone has power. And in our own milieu, we have power to change things. So they did. This is not made by paper or by institution. This establishment of human rights as we know them today is the work of people who were inspired and had a vision how to settle the disputes between the nations. The purpose of the Universal Declaration is unequivocal in its goal of peace and justice. And I'll read its preamble, one of its. It reads like this. Whereas disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, and the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want, has been proclaimed as the highest aspiration of the common people. Very clear. We want peace and justice through respect of human rights and guarantees that their rights will be respected. So it's important because I have sometimes the impression, reading the papers, that human rights has become a word, like feminism perhaps, that, you know, is kind of a fancy or something. But when you know what it means really for the world, it is incredible that we may not be convinced that what we're doing is trying to achieve peace and justice in the world. So human rights is not a fad, it's not something that will pass. Human rights is really what will guarantee us peace through justice when it's implemented in all its dimensions, which it is not today, unfortunately. But we have to start somewhere. Some progress has been made. So I think that we have to remember the purpose of the Human Rights and Universal Declaration. Now they needed, it was good to have those ideas. It was wonderful to have a charter, but they had, in order to have the countries, they had to have a place to meet. So it started with the League of Nations. And I mentioned that paradoxically, wars were the prime movers behind the search for peace through the agreement of nations to develop a system that would ensure peace. This was the case during peace negotiations after the First World War. War brings peace, and it's kind of paradoxical that at the time of war, we were looking for agreement of nations to develop a system that would ensure peace. This was the case during the peace negotiation after the First World War, which concluded, of course, by the Treaty de Versailles in 1919. At the preceding, you know, it doesn't come like nothing from getting out from nothing. It's a long preparation, long thinking, and a vision. So at the preceding Paris Peace Conference, the same year, 1919, the Constitution of the League of Nations was adopted as a means to ensure collective security. Its main objective was for countries which ratified the covenant at the time to agree to resolve their disputes by arbitration under the threat of economic sanctions against countries which would resort to war. The Traité de Versailles also established the ILO, International Labour Organization, as an arm of the League of Nations, which still today is the international body which deals with the rights of labor and working conditions under the United Nations, which succeeded the League of Nations. At the time, the headquarters of the League of Nations were in Geneva with a Secretary General. There was a British man, I think Sir Eric Drummond, who was the first Secretary General. They had a General Assembly, the Council, and the Secretariat. The Council had 4 permanent members, to date has 5. Britain, France, Italy, and Japan, which eventually rose to 9. With other elected members by the General Assembly every 3 years. That was the League of Nations. Some countries joined later, but some left. Brazil in 1926, Japan in 1933, which resigned, Japan after it invaded Manchuria and was blamed by the report issued by the League of Nations. Italy, after the invasion of Ethiopia, which the League of Nations condemned and against which it imposed sanctions. Germany was a member only from 1926 to 1932, I think, and the Soviet Union from 1934 to 1940 and was expelled after it invaded Finland in 1939. Of note, the US, which didn't sign the Traité de Versailles, did not join the League of Nations. So the League of Nations achieved some successes to preventing wars in countries such as Greece, Turkey, Poland. There were all kinds of skirmishes between these countries and their neighbors at the time. And the League of Nations achieved some success in preventing such wars. But probably its greatest challenge came in 1938 when Germany threatened to invade Czechoslovakia. And we all know Neville Chamberlain met Hitler in Germany. And the purpose was to avoid a war. The rest, of course, is history. And the League of Nations, which was unsuccessful to prevent the Second World War, didn't meet during the war, and after the war, it devolved its responsibilities to the United Nations. So that's the first meeting place. We get to the United Nations, the second meeting place, and the idea of United Nations came to light during World War II as a result of an alliance between the United Kingdom and the United States, before the United States joined the UK in the war against Germany in 1942 and signed the Atlantic Charter, said to be the brainchild of Winston Churchill and Franklin D. Roosevelt. The idea for United Nations was endorsed in further allied conferences during wartime in Moscow, Cairo, Tehran in 1943. There was a number of meetings to try to pursue that idea and see how it could work. So during 1944, a number of meetings between France, China, UK, US, the Soviet Union were held. You remember the Dumbarton Hope Estates in Washington, D.C., where these conferences were held. And it's very well known in international law. And later proposals were drafted outlining the purpose of such an organization, its membership, administrative organization to maintain international peace and security, and economic and social cooperation. So although its purpose was also basically to avoid war, it went much further than did the League of Nations in that it included the protection of human rights. Roosevelt, in its State of the Union address at the American Congress, had made clear that the proposed United Nations organization would be based on 4 essential freedoms: freedom of speech and expression, freedom of religion, freedom from want, and freedom from fear, which all are reflected in the preamble of the Universal Declaration to which I referred earlier and the principles it enunciates. So the Charter of the United Nations was adopted in San Francisco in 1945, which created the Commission of Human Rights of the United Nations, which was headed by Eleanor Roosevelt. It led to the adoption in 1948 of the Universal Declaration of Human Rights by the United Nations, with 48 member states voting in favor and 8 states abstaining. And the 8 states that abstained were Soviet Union, Belarus, Ukraine, Bulgaria, Romania, Albania, South Africa, and Saudi Arabia, just to give you an idea of the states that were, they didn't vote against. There was no vote against, but they were abstainees. United Nations was originally known as United Nations Organization, UNO, but it became the UN. Today, 192 states are members. That's my latest research of the United Nations. That's the world. Its headquarters are in New York City, whereas the League of Nations was in Europe, and it's situated in a territory that was given, land that was given by John D. Rockefeller in 1946, and it is looked at international territory. So it's not American territory, it's international territory. The UN has major agencies in Geneva: the Human Rights Council, the ILO, the Hague, ICG, ICC. They even have something in Montreal, the ICAO, and Copenhagen, Bonn, and elsewhere. So the main body is in New York at the United Nations, but also in Geneva and many other places. So the UN is financed by voluntary contributions of member states, according to a formula which takes into account, among others, the financial capacity of states. It has 6 official languages: English, French, Chinese, Arabic, Spanish, and Russian. Its organizational functions are assumed by 5 principal organs: the General Assembly, the Security Council, the Economic and Social Council, which elects the member, which used to elect the members of the Human Rights Council, which is no more the case, the Secretariat, and International Court of Justice. So this is the main organizational functions of the United Nations. It has, in addition, many specialized agencies. And I think you should know, because it's difficult to see the ensemble of all this. It has the International Atomic Energy Agency, the International Civil Aviation Organization, the International Fund for Agriculture and Development, the International Labor Organization, the International Maritime Organization, International Telecommunication Union, Food and Agriculture Organization, United Nations Educational, Scientific, and Cultural, UNESCO, which we know better, United Industrial Development Organization, UNIDO, Universal Postal Union, UPU, United Nations Children Fund, UNICEF, World Bank, World Health Organization, WHO, World Intellectual Property Organization, World Meteorological Organization, and I may have forgotten a few, but that's mainly what the agencies are under the United Nations. The General Assembly, which is the main organizational functional, is composed of all United Nations member states, and it's the main operational body. It meets once a year. Votes on important questions require a 2/3 majority of those present and voting, and each member state has 1 vote. In 2006, it established a successor of the former Commission on Human Rights. You know that it had been very criticized for different reasons, and was then only a subsidiary body of the UN Economic and Social Council. But it has become, in 2006, a subsidiary body of the General Assembly, also reducing its members. Were 53 states, and now there are 47 member states as part of the Commission on Council of Human Rights. The Security Council function is to maintain peace and security among countries. It's its main, as it was always its main role. But in order, as you see from all that developed around that, in order to achieve that, it needs a lot of other functions and bodies, labor organization and agriculture, educational, and so on. Because the aim to establish peace doesn't say what it needs, so they have the components to make it happen. The Security Council is to maintain peace and security among countries, but it's composed of 15 members. 5 have permanent seats: the UK, the US, France, Russia, and China. And it has 10 temporary seats held for a 2-year term and voted upon by the General Assembly on a regional basis. So the permanent members have a right of veto to block a resolution, but they have no right to block a debate. So these are the 5 countries: UK, US, France, Russia, and China. The Social and Economic Council has 54 members, states, elected by the General Assembly for a 3-year term. It sits once a year for a 4-week session, and its purpose is to promote international economic and social development. It also holds meetings with the World Bank, the International Monetary Fund, and gathers information, gives advice, and makes recommendations to member states. The Secretariat is headed by the Secretary General, who we know now is present Secretary General is Ban Ki-moon, who is from South Korea, and he's the leader and spokesman of the UN and helps resolve conflicts between member states. He's doing that. He is appointed by the General Assembly upon the recommendation of the Security Council. So the United Nations has had about, I think, 6 Secretaries General, and the first one, you may remember, is Trygve Lie from Norway. There was Dag Hammarskjöld, there was Boutros Ghali, there were 8 up to this day. Finally, the International Court of Justice, based in The Hague, adjudicates disputes among states, replacing the Permanent Court of International Justice as it was named before. So the International Criminal Court was added and became functional that's the ICC, we call it, in 2002 to try crimes under international law, including war crimes, genocide, and crimes against humanity. It's an independent court, but it is financed by the UN. Its predecessors are still active. The ICCY and the ICCR were specifically created for trying crimes from Yugoslavia and Rwanda. And I think there's maybe Somalia now added to this one. Peacekeeping and disarmament are also among the functions of the United Nations, as we all know. The peacekeepers are everywhere where there's a serious conflict. So this brief overview of the institutions where states meet, discuss, first the League of Nations and United Nations, the past resolution, and so on, provide a necessary background to the real issue I want to deal with now, the Universal Declaration of Human Rights. When we know how it functions, it's better to focus on what the real purpose is. So this year marks the 60th anniversary of the adoption and proclamation of the Universal Declaration of Human Rights by the United Nations in December 1948. So we can celebrate this incredible profession of faith in fundamental rights. And I quote from the Universal Declaration, "In the dignity and worth of the human person, and in the equal rights of men and women," and the goal, end of the quotation, and the goal of member states, and I quote again, "to achieve the promotion of universal respect for and observance of human rights and fundamental freedoms," as it's, end of the quote, as it states in its preamble. The Universal Declaration is a set of principles, a set of ideals to which member states agreed to adhere to and guarantee those fundamental rights to the people of their respective countries under their jurisdiction. It contains, in addition to the preamble, 30 articles which state in very clear and comprehensive language the obligations that states have undertaken. States have undertaken to give their people these rights. There's 30 of them. I'm not going to recite them. It's very easy to find the Universal Declaration. Just go on Google, for example, you'll get all this. So it's easy. I think it would be a little bit too long to, but I'm just going to quote a few articles. Article 3, everyone has the right to life, liberty, and security of the person. This is exactly what Article 7 of the Canadian Charter says. Article 5, no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. There is a Convention on Torture, and the International Commission of Jurists, of which I was the president at one time, was very instrumental in drafting that declaration against torture. I think Theo van Boven of Netherlands was a very great contributor to that. Article 7, all are equal before the law and are entitled without any discrimination to equal protection of the law. All are entitled to equal protection against any discrimination in violation of this declaration and against any incitement to such discrimination. So I quoted 3 of those, but there are 30 of them, and it's interesting that you should, especially the student, just read them all. It's worth it to know what a human being is entitled to just by the fact that he or she is a human being. The Universal Declaration is a declaration of basic principle on human rights, a statement of objectives and ideals, and as such is necessarily vague, hence the need to adopt more specific conventions, treaties, etc., to make it easier to enforce, as well as to better inform member states of the rights They themselves guaranteed their people by signing the Universal Declaration. So the International Bill of Human Rights, which since 1976 formed part of the international law, consists of, in addition to the Universal Declaration, the International Covenant of Economic and Social and Cultural Rights, the International Covenant on Civil and Political Rights, adopted in 1976 by the General Assembly, plus 2 of its optional protocols. This is the body that forms international law. The numerous international human rights laws were adopted during the years following the Universal Declaration, and I will name you just a few. The European Convention on Human Rights was adopted in 1950. There had to be further developments because objectives and ideals are wonderful, they need to be there, but in order to be more specific about the guarantees that are included in this declaration, these conventions, the European Convention on Human Rights, 1950, the Convention relating to the status of refugees, 1954, the Convention on Elimination of All Forms of Racial Discrimination, 1969, International Covenant on Civil and Political Rights, 1976, International Covenant on Social and Cultural Rights, 1976 also, Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, 1981, the Convention on the Rights of the Child, 1990, Charter of Fundamental Rights of the European Union in 2000. So I'm just telling you that the Universal Declaration produced these conventions to which certain countries, not all countries, adhered to, were participating. Not surprisingly, the constitution of many countries, particularly new countries, such as South Africa and Canada, were greatly influenced and inspired by the Universal Declaration, and the fundamental rights they guaranteed to their people borrowed heavily from the Universal Declaration, which their countries had signed. As I said, there's word for word in many constitutions, the articles of the, some articles of the Universal Declaration. The Universal Declaration, in the words of Eleanor Roosevelt, and I quote, may well become the international Magna Carta of all men everywhere. End of the quote. It was praised, and I quote, as one of the highest expression of human conscience of our time. That's Pope John Paul II in 1995, and more recently in 2003 on behalf of the European Union, which said, over the past 55 years, humanity has made extraordinary progress in the promotion and protection of human rights, thanks to the creative force generated by the Universal Declaration of Human Rights, undoubtedly one of the most influential documents in history. It is a remarkable document, they continue on, full of idealism, but also of determination to learn lessons from the past and not to repeat the same mistakes. Most importantly, it placed human rights at the center of the framework of principles and obligations shaping relations within the international community. An end of the quote. That's the European Union, which quoted that in 2003. So it is, however, at the same time, saddening that tragedies of international dimensions, such as Darfur, Somalia, and now Kenya, and others are still occurring in this day and age, and that human rights are not only ignored in many countries, but denied. Torture is still rampant. Women and children are inexistent, and I could go on and on. But perhaps it is time now to listen to René Cassin's admonition in 1968, 20 years after the adoption of the Universal Declaration, to which he contributed himself so much. I met René Cassin in 1976 in Tunisia. We had a big conference on civil, the countries of civil law meet, we call it CLIDEF, and I was the representative of Canada and to see this man, which is white hair. He died a couple of years later, white hair, and walking with us in the streets of Sidi Bou Said, who had done so much himself to, as a humanist, as a professor, as an international human rights person. And he said this in 1960, 20 years after, and I quote, "Now that we possess an instrument capable of lifting or easing the burden of oppression and injustice in the world, we must learn to use it." That's where we are. And I want now to reflect on the basic philosophy which inspired human rights. And I will do it in talking about human dignity and equality. The Universal Declaration, with a recognition of the inherent dignity of all people. Human dignity is the lens through which all those fundamental rights take life. Key international documents imply that dignity is a value from which other rights are derived. The promotion and protection of human rights is at the core of a society which is just and humane. Human dignity implies justice and compassion. Human dignity implies justice for all. We have to approach justice by trying to feel the sense of pain of those who are the victims of discrimination and disadvantage as much as we have a feeling for injustice if we want to effectively pursue justice. In the words of former Minister Justice Erwin Cutler, in which equality is not only an ideal, but a constitutional norm in which we extend a hand to those disadvantaged and discriminated against, in which we build bridges rather than erect walls in the pursuit of justice for all. No one should be relegated to the margins of society. It is a question of human dignity. End of the quotation. We need a culture of respect, a culture of human rights, instead of a culture of hate, a culture of love rather than a culture of the question of human dignity. End of the quotation. We need a culture of respect, a culture of human rights, instead of a culture of hate, a culture of love rather than a culture of guns. But by the mobilization of a constituency of conscience, the tragedies that come to define our time can be prevented if we really believe in the dignity of man. Everyone in the world dreams of peace, of a time where there is no longer wars, terrorism, genocide, crimes against humanity, famine, injustice, human refugees, as a guiding light. The International Tribunal for Former Yugoslavia stated in one of its judgments, and I quote, "An outrage upon personal dignity is an act which is animated by contempt for humanity." The Tribunal for Former Yugoslavia stated in one of its judgments, and I quote, "An outrage upon personal dignity is an act which is animated by contempt for human dignity or another person." End of the quote. As a matter of fact, the tribunal in Arusha, where one of the judges who is now at the ICC in Geneva was the Chief Justice, Navi Pillay, rendered the first decision on rape, systemic rape, as a war crime and a crime against humanity. So it's very interesting to see we've moved from not accepting that there was a big discussion in Rome and Vienna about including rape, a systemic rape by as a crime of against humanity, but in a judgment, which was the first one, Justice Navi Pillay wrote that. So it's we're getting somewhere. The supreme value of democracy is the dignity and worth of individual. The Constitutional Court of South Africa, in a case called Dawood, etc., stated, and I quote, "Human dignity informs constitutional adjudication and interpretation at a range of levels. It is a value that informs the interpretation of many, possibly all other rights. End of the quotation. There is direct reference to human dignity in a number of court decisions around the world, including the Supreme Court of Canada, just to mention the case of Law and others. Lord Huffman of the House of Lords, in a case called Matthews versus something, wrote, and I quote, "Human rights are the rights essential to the life and dignity of the individual in a democratic society." End of the quote. The Covenants on Social, Economic, and Cultural Rights and Civil Political Rights, as well as the Convention on the Rights of the Child, state in their first preamble, and I quote, "Recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world." End of the quotation. It is therefore amply apparent that there is a fundamental link between human rights and human dignity, and that it is well established in human rights law. Speaking now of my pet project, my pet subject, equality. I couldn't do anything without talking about it. It's so fundamental. It's amply apparent that there is a fundamental link between human rights and equality, the right to equality being itself a fundamental right. From time immemorial, human beings have thirsted for justice. Our pursuit of this ideal has necessarily translated into a long and difficult search for truth, impartiality, and ultimately equality. Alexis de Tocqueville, it's not today, it's a long time ago, but he's as applicable today as it was then, has said, equality is the foundation upon which all other rights are built. He wrote this book about democracy in America, and I quote from this. As we look to existing human rights, it is important that our focus be on equality. For if equality is a controlling principle, our approach to this ideal is telling. If equality doesn't shape all other rights, then other rights can only be symbolic, devoid of true meaning. In principle, most powerful tool for the advancement of rights, and the search for equality is indeed a human rights issue. Human rights legislation in 1977 contains a number of fundamental rights which were not guaranteed by any other at the time, including sexual orientation, but now as added and as proposed, and it will be voted at the legislature eventually. There'll be a commission, a parliamentary commission to discuss that shortly in February. Article 42, that equality between men and women is guaranteed to all people of our province. So the debate is it necessary? Is it essential? Why do you put that there? It's the same article that is in Article 28 in our Canadian Charter of Rights. Why is it important? Because it's a statement of a fundamental value of our society, both Quebec, our provinces, and Canada. And women have fought so hard to have this Article 28 in the Constitution. There is power in groups and society. And in that occasion, women tremendously had a tremendous voice in putting this Article 28 in the Canadian Constitution. Now it will be in the Quebec Constitution because we feel that it's a fundamental guarantee from which all other rights are really, it's a lens to which all other rights should be interpreted. So equality is important to all of us because of our deep-seated desire for justice. Inequality is injustice by itself. And from inequality and injustice, it flows oppression. And from an inequality fosters hate, social unrest, wars, revolution, as well as many other ills in societal as well as private relationships. The French, as I mentioned earlier, Revolution in 1789 may be the best example of a society of unequals, which perhaps prompted the liberty, equality, fraternity trademark of France. Oppression can have no place in the society we are struggling to mold for our children and grandchildren. So if I were to ask you, any of you, how you would design a model society without knowing a priori your role in it, your place of birth, gender, ethnic, racial group, what would your society look like? I would venture to say that most of you would put in such a position, would design a society that treated each and every individual with dignity and offered everyone equal and meaningful opportunity to realize his or her goals, dreams, and expectations. That's what Martin Luther King, which was celebrated in the US Monday, I think, said, I have a dream. Well, you have to have a way to achieve those dreams and goals and expectations. This is why today's struggle for equality is so important. It will shape the society of tomorrow. Equality has developed through a number of decennies and centuries. Aristotle, for example, spoke of equality in terms of proportionality. Equal should be treated equally, but unequal should be treated in proportion of their inequalities. It's separate but equal, so the doctrine. But that was Aristotle. And this approach, of course, begs the questions. Equals or unequals in what? Aristotle distinguished between persons of free and noble birth and the slaves, or indentured servants. He advocated for equality according to merit, but what he deemed merit would not be acceptable today. We no longer speak of unequals or of merit. Instead, most of us do recognize that true equality is an ideal. We see that Aristotle's approach and similar approaches have served only to perpetuate inequalities and reinforce this empowerment. Egalitarianism, the next step in the development of equality principle, began with the Reformation, with Luther. He complained that differences or inequalities among human beings were arbitrary and unacceptable. They are the product, he said, of the existing hierarchy within the church, and it was only later that his ideas inspired discussion as to legal and political equality. The Reformation's notion of equality was no more refined than Aristotle's, for equality in the Reformation tolerated inequalities. But in the mid-18th century, John Locke pursued the ideal further. Locke brought egalitarianism from the realm of the spiritual to forums that were both political and ideological. Locke's thesis was that each individual is equally entitled to freedom. Our equality flows, according to him, from the idea that no individual may be subjected to the will or authority of another person. In this sense, Locke constructed the universal and equal right to be free from state intrusion. This, in turn, is said to have inspired the American Declaration of Independence. The American Declaration of Independence hailed the equality principle as the fundamental building block of the new nation of the United States. And I quote, "We hold these truths to be self-evident that all men are created equal, that they are endowed by their Creator with certain inalienable rights." End of the quotations. 13 years after that declaration, the first article of the French Declaration of Rights of Man heralded, and I quote, "Men are born and remain free and equal in rights," end of quotation. Yet, make no mistake, the 18th century notion of equality was severely limited. Slaves and women were not included, and equal rights were severely limited. Jean-Jacques Rousseau, the late 18th century continental philosopher, had a very different view of equality. Rousseau's social contract rejected egalitarianism, emphasizing instead the common good. According to Rousseau, human beings are naturally equal. We create governments by social contract in order to correct inequalities caused by the ills of civilization. For Rousseau, the only legitimate form of government is a government of the people. It's no wonder that at the time Rousseau's work was banned in France, probably excommunicated, nor is it a surprise that his thesis inspired a revolution and the cry, of course, liberty, equality, and fraternity. John Stuart Mill and later Immanuel Kant and Simone de Beauvoir pursued this interrelationship between individual human dignity and the good of the community. They brought a more humanitarian vision and emphasized that equality is about dignity and respect. Here, I just want to, quoting Simone de Beauvoir, I just want to interject that the word feminist and activist and whatever has kind of a very pejorative connotation because people don't understand what it means. Feminist, for me, for Simone de Beauvoir, for people who understand what it is, it's simply that women have the same right as any other participant in society, every other member of society, to be treated with dignity, with respect, and with consideration. This is what feminism is. This is what human rights are. This is not chapels or hate men or... No, if people understand really what equality is, this is it. Feminism is equality. It's in our constitution. So I just wanted to interject that because in a certain way, people want to demonize the word feminist. But its real meaning has nothing to do with a sect or with hate. It has something to do with women having their place under the sun and being treated with dignity and consideration and respect. So I'm talking about Mill and Kant and Simone de Beauvoir. They brought a more humanitarian vision and emphasized that equality is about dignity and respect. It is these late thinkers who gave rise to human rights and the notion that human beings should only be free from intrusive state, not only be free from intrusive states, but they must also be free from discrimination. This is one of the principles at the base of human rights. Now, equality around the world, while equality has taken a different meaning over the centuries I just explained, it has matured. As societies we live in become more conscious and self-aware, indeed, the notion of equality is constantly being recast as we become increasingly cognizant that the constituent elements of society do not conform to the white male-dominated values and power structures. We see what's happening in the States actually with the primaries, Obama and Clinton, the race plays. We thought it was finished, but no, it is not. We see how racism plays still a big role in the United States. So equality is gaining recognition as an important issue throughout the world. In spite of that, in our global village, equality is an issue that concerns and affects us all. The revitalized international commitment to equality is apparent in a number of areas. The principle of equality is embodied in the international document as the Universal Declaration, the Convention on Elimination of All Forms of Discrimination Against Women, the International Covenant on Civil and Political Rights, and name it. It is the dominant theme of the new constitutions, such as South Africa, Canada, India, and I can name many others. From its introduction into the global dialogue, the equality principle has attained universal recognition. The Canadian Constitution of 1982 and its entrenched Charter of Rights and Freedoms have guaranteed equality as a fundamental right under Article 15, as we all know. Equality without discrimination on account, amongst others, of race, sex, religion, national or ethnic origin, color, age, or mental or physical disability. Since then, some other areas of discrimination have been added, such as citizenship, sexual orientation, and probably others will be added. Growing international links are influencing and changing judicial decisions, particularly at the level of apex courts throughout the world. As social debates around the world become more and more similar, so are the equivalent legal debates. In this sense, reference to international law and human rights instruments by courts in discharging the constitutional mandate do strengthen and develop a common language of equality through human rights. There's a decision from the European Court of Human Rights a couple of days ago about criticizing France for having not permitted a lesbian woman to adopt a child. And so they reversed the decision of France and blamed France for not having followed the Universal Declaration or the Convention on European Human Rights. The rich, you can see how it has invaded all walks of life, courts, public, convention, parliamentary discussion, debates, and everything. It's human rights are at the heart of our debates in Canada and everywhere else, and also in the international documents that are built, actually. The rich contextual understanding of equality emphasizes dignity and respect for all. It recognizes that true equality requires substantive change and accommodation rather than simply formalistic egalitarian treatment. This vision of equality is premised upon the fact that individual dignity may flow as much from one's own value as a human being as from one's gender or one's membership in a racial, cultural, ethnic, or religious group. In this sense, substantive equality recognizes that equality is not about being the same, but it is about taking stock of differences. The Americans have rather a very simplistic, formalistic equality treatment. Canadians have a much more richer understanding, we'd call it substantive equality. For example, you work at $5 an hour or something. Well, it's okay, for some people because others in the same group, in other groups are paid much more. Doesn't matter, You're equal, you're working. So this is a very simplistic way of saying equality. We don't do that in Canada. We really have a rich definition of equality, which recognizes the differences in people. The Supreme Court decision full of those decisions. Eldridge, for example, here in British Columbia, that's the case. I think it's Eldridge, where a person who couldn't hear, who was completely deaf, was not able to have access to, had access like everybody else to health care, but could not have the same quality of access. So the court said that the health care system should provide interpreters for those people who couldn't even speak to their doctors or explain their sickness. So they had, according to the American simplistic definition of equality, there would be no recourse possible. You have the same access, but you don't have the same quality of access. If you cannot explain to the doctor what your sicknesses are, what you resent, what you feel, or what is wrong. So the American doctrine of separate but equal, which has been applied for so long to the blacks in the United States, is the antithesis of the Canadian and many other countries' approach to equality. Equality is about promoting an equal sense of self-worth. It is about treating people with equal concern, equal respect, and equal consideration. In Canada, these are the values that underlie equality and which have shaped our jurisprudence in human rights. A couple of examples from that jurisprudence may illustrate cases like Andrews, Eldridge, and many others will illustrate the point of the rich understanding we have of equality. If we all speak the same language of equality in our daily lives, the language of respect and dignity for each human being, which is an attempt to add layers of tolerance, as Rosie Abella, now at the Supreme Court of Canada, said, we would be working for a better world. The experiment of an NGO in Pakistan that I recounted is worth remembering. Speaking the language of equality will ensure justice for all and a better world for all. I leave you with this phrase from a great American judge. Equality is a miracle and justice is a heaven we can seek every day, all the time, from each of us. This is a great human rights guy, Leon Higginbotham, in open letter to Arthur Littman in 1988 in the Law Review. So I think I can't do better leaving you with this quotation. Thank you very much. I might go.
Good evening. My name is Michael Jackson. I'm a professor of law at UBC, and it's my privilege to MC the question and answer period Madam Justice L'Heureux-Dubé has kindly agreed to conduct.
I was just wondering what your outlook on the future of the United Nations and universal, as in global human rights, is. I guess it's optimistic, but do you think we should be facing some of the problems that we see now?
I didn't quite get the thrust of your question, so perhaps we can take a few questions and then try to answer them. I haven't really, my hearing is not good, so.
To have a little answer to this man's question. My name's Gail again. He was asking you, Claire, what optimism you had for the future. And I just wanted to say that as well as working with Lawyers' Rights Watch, I also work with an organization called Lawyers Against the War, which for the last few years has brought me into close and uncomfortable contact with all the atrocities and horrors that we're witness to around the world. And one of the reasons why Claire is here today, and one of the reasons why Lawyers' Rights Watch and our UBC partners are putting on this series of lectures and wanting them to develop into a center is to enable people like you, thank you very much for asking this question, and people like me to develop the tools to do what Renee Cassin said, that now we have this body of law, these bodies of human rights and humanitarian law that were developed by people after the Second World War that were sick and tired to do the atrocities of the Second World War. And now it's up to all of us, each of us, to learn how to use those. And that's what I'm hoping. That's my optimism, that we indeed will learn how to use those to achieve peace peacefully and universal human rights, because you know what, we don't have any choice.
You have to be optimistic. You have to think that people like you who are young will carry the flambeau. I don't know in English what's the word, but anyway, so in that sense, I'm very optimistic for the future if our children and grandchildren go on and do what they have to do to have a peaceful world and a happy world and a happy life, and can realize this. So I can only say that for the future. I would be optimistic.
So.
Yes, thank you. Madam Justice, I enjoyed your talk very much, but a couple of points were brought to mind. You talked at the very outset about this process through the schools in Pakistan of talking about the language of human rights. I'm not sure if those lessons are being taught in the madrasas, for example. Perhaps you might want to talk about that. Secondly, you also mentioned a couple of people in your synopsis of the period of enlightenment, which kind of surprised me. And Martin Luther, who we all know his history, but he had a little something extra going on. Christianity was founded on the basis of theory and practice. The theory is that you have faith, and the practice is that you do practice. You don't need charity to gain access to the kingdom of heaven. So I don't think that he's another great example you might want to continue using in your speeches. But my question is this. At present, the United Nations is presently constituted. All of the ambassadors, to my knowledge, are by not elected regimes. The people are not elected against the ambassadors. So I'm wondering if that can be, if you could talk about the feasibility of having ambassadors to the United Nations elected in the future. And just if you would mention a few words about that, I'd appreciate it. Thank you.
Just to answer one part, because I know that others would like to answer also. When I recite what happened as far as equality is concerned, I see how people have tried to base a theory. I don't agree, as I said, it's just the way it went from one to the other and one to the other to come to what we call in Canada particularly equality. So it's not whether you approve or whether they had you to realize that it's not a course on Kant or it's not a course on this. It's just the steps that appear to be taken. I was 30 years in the judiciary, so we're not supposed even to talk about politics.
Somebody said, poverty is itself a great violence. We talk about violence and we forget. Poverty itself is a violence, and it's spread throughout the world. If we ignore that, we cannot achieve equality and justice.
Well, I can give you some ray of hope. The fact that these conventions have been signed and ratified, it has, not everything can be achieved in one day, but the fact that this is within the radar of countries. In South Africa, for example, the Constitutional Court ordered the government to give, I think it's electricity, or I think it's something to permit them to live better, because of these conventions. You see, it's percolating through the system slowly, too slowly. Poverty is not, I'm the first to say that to have so many billion people in poverty and missing the essential thing for life, because we are guaranteed in these documents the right to life, what it means, at least a roof and something to eat. It's awful in this day and age. But the ideal is there, which is a way of hope. And then in some countries, they are trying to incrementally implement. That was the case of South Africa in one of those decisions. I don't remember the name, but it was one of them. And they said, we cannot order the government to give everybody everything. At the moment, we don't have the money. South Africa, particularly after the apartheid, and so. But they ordered the government to do a step forward to help people. I think it was electricity, or water, something like that. So it's true that it's a sad constatation to see that there's so many people with all those ideals who cannot even enjoy the basics of life. We are all here to deplore it, and we are human rights people in order to try to achieve a much better world. But it's true, we have to say that it's still an ideal in many, many countries. But having this, I call it a common denominator throughout the world. Courts are better equipped, and courts are very powerful. When they decide something, it's the law of the country. So they have these instruments, common denominator, to push ahead for a better world and peace, of course.
Yes, yourself. Thank you. Thank you for coming and speaking with us tonight, Madam Justice. I do have a question, but to just a few words before that. When we speak of human rights, we speak of human rights as universal, inalienable, and I think that there's something implicit within the notion of inalienable human rights, in that they are also ahistorical. They've always existed, right? And
No, I said it started a long time ago.
oh, I'm not saying that you said that. I'm just saying that generally speaking.
A long time ago, in order to reach where we are here. It didn't come in one day.
I'm not
That's
saying
the
that you
idea.
said that. No, definitely. No, and I agree with you. Absolutely, it's been a problem. And this is sort of a thesis that I'm extending, is that perhaps, that they are a process of a lot of struggle over time.
Yes.
And so today, when we speak of human rights, we hear of. It seems that there's a particular notion of human rights that's taken hold, in much discourse and dialogue, and that's that civil rights, are comprised of basically civil and political rights. But there's also that aspect of like social and economic rights, and what we see is, with this Universal Declaration of Human Rights, that it was actually a product of war, negotiation, and really a product of almost the Cold War as well, you could say. With social and economic rights on one side, civil and political rights on the other side. The argument further to that is that social and certain forms of economic rights are incompatible with capitalist economies. Right? They inhibit the circulation of capital, and there's other political economic reasons. So how can we ever have this is just a question, and it'd be interesting to hear from a Madam,
I don't
Supreme
have
Court
a
Justice.
crystal ball.
Yeah, it's I just I'm hopeful as well, but I just can't see how we could possibly have like a realization of social and economic rights as well in the types of societies
They are
that
not
we're organized in.
guaranteed. They are not guaranteed by the Charter of Rights.
No,
in
absolutely
Canada.
not.
No,
Definitely.
Eventually, there was a decision in Gosselin where Mme. L'Heureux and myself were dissenting about the right to life and the right to kind of economic rights, but we were in dissent. Eventually, I am sure that the whole notion of human rights will evolve, even in Canada here, to include more and more of those types of rights. But it is not in our Constitution, actually. And so we'll see how it evolves. I don't think it can go back to the Dark Ages. I think we can hope only that we develop that conscience about the necessity to guarantee to people that they can live decently, and they have. It's not so much capitalism. Capitalism depends on the definition you get, but Canada is particularly capitalist socialist. We have heavy taxes. We give, we have the basic subsistence for people. So, by comparison, by other countries, universal health care, for example. We cannot minimize too much. We cannot maximize either. But I think the notion of capitalism, of socialism, and everything is a very tough question. If people, they have tried it in the communist country, that people would be equal, nobody will earn anything. So what does it give them? What has it given to people? They rejected it. So there has to be a system that can have the two objectives together. People have to have jobs in order to survive, and the capital. Bill Gates just made a big declaration at Davos today or yesterday about the fact that the rich people should give the money to permit to society. So there will be ideas that will eventually. You have to be hopeful. What about? If you're not hopeful, nobody will get up and try to fight for those rights. We have to fight. We've had to fight since the times immemorial. So I think it's.
I'd agree with that.
I'm not going here to say capitalism is bad. No, because what is the notion of capital is a whole debate in itself. So I think Canada has a certain measure of socialism enough, because I think we are one of the countries where the taxes are the greatest, to give some sort of health care. This is one aspect that you cannot neglect on that, eh?
Yeah, it's pretty cool.
It's a very interesting issue of the intersection and limitations of law in the context of economic and political realities.
That's correct.
And it relates again to one of the points Mme Justice L'Heureux-Dubé made, that the responsibility to press an agenda of human rights and creating a culture of rights which allows people to live with dignity is something which you cannot leave to the judges, even as distinguished and as elegant and eloquent judges, Mme Justice L'Heureux-Dubé. It's a responsibility of all of us in every way we can to push that agenda and make our voices heard, and not think that judges alone or politicians alone will bring about the result in which we can all stand together and be proud of who we are and how we live with dignity.